sound, swear, affirm testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God.
Sir, please state and spell your name for the record.
Matthew Farrell. Matthew spelled Matthew. Farrell, Ferrell.
Where are you employed?
Clarksville Police Department,
How long have you been employed there?
going on 16 years.
What is your current role?
Sergeant,
What was your role in or about September 22nd of 2021?
narcotics agent.
Were you a drug agent?
Yes, drug agent.
Do you recognize the individual seated here today?
Yes,
Who is that?
Billy Hollis.
Your Honor, for the record, he's identified the defendant.
He has identified the defendant.
Do you ever recall an incident on or around the September 22nd date, 2021 involving Mr. Hollis?
Yes,
Where was that at?
that would have been at, well, several places, Big Lot, Shell, and also Oak Haven Motel.
Now, you testified you were a drug agent. Were you doing a drug investigation that day?
Yes.
What led you to have an incident with Mr. Hollis?
We were actually at the Big Lots. It's on Riverside. I can't remember the numerics off the top of my head. We were observing, just doing normal surveillance in that area for high drug areas. We observed one vehicle, I believe it was a gray Honda, pull up as an agent put out that was on surveillance, do a hand-to-hand with another vehicle. Those vehicles then cross Riverside to Shell, which is directly across the street.
Hand to hand, what does that mean? Just generally speaking for the record?
You
Drug transaction?
Yeah, drug transaction. Yes,
Okay.
sir.
And did you ever see who got into that car? Did you have a way to where you could see who got into that car at the Shell gas station?
Yes, me and several agents did.
Who was it?
Billy Hollis.
Man sitting here today at the defense table?
Yep.
And what did you do after that, after seeing him get in the car?
Both vehicles then left the parking lot of the Shell gas station. We had several UC undercover vehicles in the area conducting that surveillance. They followed that vehicle and the one that was operated by Mr. Hollis. There, we pulled all the way around. We went up, took a left up Boot Hill and went up Fort Campbell Boulevard, Providence, north. From there, we ran Mr. Hollis's information, determined he had a suspended license. There, I attempted to conduct a traffic stop at the Oak Haven Motel parking.
It said Boot Hill. Is that like the hill on
I'm
Fort
sorry,
Campbell Boulevard?
Yeah, it's off of Riverside, turn left, you're going north, going up Boot Hill, that's Providence. Providence then turns into Fort Campbell Boulevard.
That'll take you to Fort Campbell if you kept going that way.
We were running his information based on the vehicle to see who was in there. Once we realized he had a suspended driver's license, that was no probable cause to make a traffic stop.
Did you ever try to make a stop on him?
Yes.
And tell me about that. What happened?
He pulled, the vehicle operated by Mr. Hollis pulled into the Oak Haven parking lot. That's a motel off of Fort Campbell Boulevard. When he pulled into the parking stall, I initiated my emergency lights and sirens. From there, the vehicle backed up and took off.
So did Mr. Hollis stop for the lawful command to stop?
Nope.
Okay. This area, Boot Hill and Fort Campbell Boulevard, is that heavily trafficked? Is there a lot of people there usually?
Yes.
What happened to the other traffic on the road when Mr. Hollis was told to stop?
Several vehicles had to stop as he entered back onto Fort Campbell Boulevard at a high rate of speed.
Would he have hit them otherwise?
Yes.
Did he ever pull over for you that day?
No.
Okay. Now, he's here today on a motion for furlough. Based on your experience with him, do you think he'd be a good candidate to trust to release out and hope that he would come back to jail or court for his appearances?
Absolutely not.
That's all that I have. Thank you.
Mr. Lockhart, you may cross-examine.
No question.
Thank you, Detective,
you.
or you may sit down, Officer. Stevens and McCoy, next witness.
That's state's proof, Your Honor.
State has rested their proof. Does defense have any rebuttal proof?
Yeah, if you can call Mr. Saul back, there's a brief.
So I'll remind you, you remain under oath.
In regard to those court dates, are you confident it was January the 14th that you were not in court for your brother's death, or could it have been the 28th?
No, he died on December 31st and his funeral was on January 15th. I was
Okay.
traveling on the 14th.
Okay,
I can provide an obituary supplemental to the record if you like.
no, that's fine. And the 28th, you were not there in court? January 28th.
I don't know. I already asked and answered that.
You
I don't-
did? Okay.
Yeah.
So you don't recall if you were there?
I don't recall. I know that it was reset. I don't know if I was here that day or if it got reset again without me being here, or if there was an issue with his transport. I know there were at least one or two occasions when I went to visit him at the jail. And he was, I thought he was here, but he had been moved to Clarksville for the sake of his Clarksville cases. So I don't know if it was one of those times. Honestly, I don't know.
And if there's a letter in the court file where he wrote saying he thought he had court on the 28th, and the clerk told him that it was reset to June, you don't argue with that? I mean,
I don't know.
okay. May I approach?
You may.
Ask you, do you recognize that?
I mean, it's in my handwriting. Yes.
Right. So at some point in time, after the 6-year offer, you gave an offer to Mr. Hollis reflecting what?
I don't know when this offer was made to Mr. Hollis.
I didn't ask.
You just asked
The
me.
date.
You just asked me when. I just told you I don't know when.
All right? You testified earlier, you didn't even talk to him until the 14th, so I'm just,
What?
logic would,
This, okay. This was an offer that was made at some point related to pleading to a DUI first, felony evading, theft, possession of a weapon, and paraphernalia. All to serve concurrently, a global settlement of 4 years of 30% to serve, all concurrent to whatever Montgomery County might give them. This was not anything that was, this was very early in the process. Because I remember when he didn't want to do this, I thought I may have a problem with Mr. Hollis because he's been around the block and he just rejected a very reasonable offer. I remember this was very early in the process.
well, would it have been before or after the 6 years community corrections?
Before.
And how do you know that?
Because I remember the 4 at 30 thinking that that was a gift and he rejected it. And I remember thinking how foolish that was.
Okay. But you didn't testify this offer before.
Because you didn't show me this until just now.
That you didn't remember that there had been,
I didn't remember this. I
An
read it.
offer?
I remember thinking he was foolish for doing that. There were so many offers that went back and forth on this.
yeah, I moved this as an exhibit.
Well,
Would your file help clarify when these offers were actually made and when they were revoked?
There was some notes in there about it. I remember that offer because I remember when I wrote it out, he would be foolish not to take that because I was shocked at how good the offer was. Because I knew Montgomery County was going to give him some time, most likely.
Yeah, and I will make the other offer a part of that. This is a corrected.
You may.
So I guess maybe if you could refer to your file, it might help you as far as when the offers were made, what the offers were, when they were revoked.
One thing my file will not help with is my distinct memory that Mr. Hollis never fully accepted anything.
Right, because by fully accepting, you enter the plea in court.
He never accepted anything.
So you're saying every offer you made, he rejected?
He either rejected it outright or he rejected it because he wanted to see what Clarksville was going to do.
And again, not to rehash, but you told him that'd be a wise thing to do to check on Clarksville.
The answer is exactly.
Same.
Let me rephrase it. You're not saying he outright rejected every offer.
What I just said is he either outright rejected the offers, or he would hang a contingency on his acceptance of it based on Clarksville.
And would notations and emails and notes of phone calls in your file better help establish what was made, what was rejected, what was revoked, times received, that type thing?
I doubt that I made a notation of every detail of every conversation with Mr. Arnold, Mr. Stevens, and Mr. Hollis. I do know that he never accepted any offer fully.
And so again, would your file help you?
Objection asked.
My file wouldn't help me because I have the distinct memory of thinking the whole time that Mr. Hollis was going to find out what my tax instructor would tell us, that pigs get fat and hogs get slaughtered.
I understand Mr. Saul wants to say
I'm not
whatever he
gonna
wants to say.
require Mr. Saul to open his file and bring forth anything. He has testified under oath as an officer of the court that this defendant never accepted any of the offers. Now, the fact of the matter is that there is no written offer from the state that has been produced to me. There's some handwritten notes here, but that's oftentimes done in negotiation. But there is no written offer, printed offer from the state of Tennessee to Mr. Hollis, setting forth what they were offering. Nor is there any evidence that he accepted any of those offers. What I have is that Mr. Hollis is saying he was willing to accept an offer, and then the offer was withdrawn and substituted. But there was never any official offer that was accepted by the client. So I'm not of the opinion that the defendant is entitled to open up Mr. Saul's file to try to make something into the situation. So I'm not going to require him to open his file and go back and do that.
Well, just for the record, Your Honor is not going to allow Mr. Saul to provide notations or emails as to when offers were revoked or pulled.
Correct.
Nothing further, Your Honor.
Step down, Mr. Saul. This case is here before this court on two motions, one of them being the motion to enforce the original offer that was allegedly made in this case. And this court finds that there was never any official offer that was accepted by the defendant that was made by Mr. Arnold for 6 to 8 years or 6 years or whatever. There was never any offer. There's no proof of any such offer that was accepted by this defendant. That the credible proof that's before the court is that there was continuing negotiations, that Mr. Hollis was concerned about the charges that were pending in Montgomery County, and that for that reason, he was not willing to accept the offer and enter a plea until he knew for sure what was, and it's logical that that would be the case. Once Mr. Arnold left, the court finds that a new assistant district attorney was assigned to the case. It has been alleged that there is some malfeasance in his withdrawing the offer and offering a more substantial. First of all, the court finds that Mr. Hollis is not required to accept this 25-year offer. He is free to plead not guilty and go to trial as any other defendant who receives an offer that they don't accept, that they don't find palatable. And therefore, this court does not find that there is any basis upon which that the court can force the state to offer him an offer that he is unwilling to accept. Mr. Hollis is facing a driving under the influence charge, evading with a risk of death involved, reckless endangerment, failure to obey traffic control device, speeding, theft of property, $10,000 to $60,000, possession of a handgun under the influence ×2, which means 2 different counts, possession of burglary tools, being a felon in the possession of a weapon ×6, simple possession, possession of paraphernalia, aggravated assault with fear ×4, prohibited weapons with explosives ×3, driving on revoked license, second offense, evading arrest, resisting, repress, halt, arrest, or search. Those are the charges in this one case. The affidavit of complaint, and I'm reading this into the record to show why a new assistant taking over a file would review the file and make a determination of whether or not they were willing to stand by the prior offer or whether there was a basis for making a different offer. This affidavit is by Sergeant Mealer of the Ashland City Police Department. He states that on the date in question, August the 14th of 2023, I was stationary on 41A at Boat Factory when I clocked a white van eastbound at 68 miles per hour in a posted 45 mile per hour zone. I attempted to stop the vehicle and it fled on I-24 eastbound, running the red light at Highway 41 and Highway 49. We continued our pursuit for several miles. During the pursuit, the driver, Billy Hollis Jr., attempted to strike law enforcement vehicles a total of 4 times during the pursuit. His vehicle was ultimately spiked and came to a stop on Clarksville Pike at Manchester Drive, where he and his passenger, Tasha Perry, fled on foot. Both subjects were taken into custody. The vehicle's tag did not match the vehicle, and the VIN number came back stolen out of Oak Grove, Kentucky. Inside the vehicle was approximately 0.5 grams suspected marijuana, miscellaneous paraphernalia, 2 handguns, 3 shotguns, one of which had a barrel shorter than 16 inches, 3 explosive devices or grenades. Driver's license check on the driver revealed he is suspended as of 4/12/2021 out of Montgomery County for failure to pay costs, fines, taxes on criminal offense. Both occupants are convicted felons. Once we caught Mr. Hollis, he refused to identify himself to law enforcement. Mr. Hollis had an odor of alcoholic beverage coming from his breath and person, as well as the extensive drug paraphernalia. He was asked to conduct standardized field sobriety tests, and he refused. He also refused implied consent. Now, I read that into the record to make it clear that a different assistant district attorney would have the right to review that record, and that absent any proof, which there is none in this record, of an inappropriate or a motive to somehow personal vendetta against Mr. Hollis. This is simply a fact where assistant district attorneys changed. There was never an accepted offer that had been made and accepted by the defense. And as a result of that, the new assistant district attorney looked at the charges, as this court has looked at the charges, and made a decision that he felt that the record and the charges, if convicted, would result in a higher sentence. The proof is clear in this court's opinion that the credible proof is that there were discussions, there were offers made that were never accepted because of these other pending charges in Montgomery County. And as a result of that, there was never a firm plea agreement that was on the table, and that upon the change of assistant district attorneys, that there was a valid and ascertainable reason for the change in the plea agreement and the plea offer rather, and that there was no proof or evidence in this court of any malfeasance on the part of the district attorney or any reason why that would have been revoked. As a result of that, the court denies the motion that the defendant has filed to enforce the original plea offer, because this court does not find there was a verifiable firm plea offer ever made during the negotiations. Second, the court considered his request for and I would again finalize by saying that on that issue, Mr. Hollis is not required to accept that 25-year offer. He is free to go to trial as any other defendant, and he is presumed to be innocent, so we'll give him a trial date, and he may go to trial if he chooses to do so. The last thing is his request for a furlough, and based upon this court's opinion, it is not prudent to grant a furlough to Mr. Hollis prior to the finding of guilt or innocence in this case, based on his extensive criminal record. And I would point out that he was considered and then later rejected by the drug court. And I know Mr. Lockhart's familiar with that. He was rejected by as a participant in the 23rd Judicial Recovery Court, which in this court's opinion is another indication that a furlough while the case is pending would not be advisable. So both of these motions are respectfully denied. That concludes our business before court today. This court stands adjourned.